the legislature with a problem, the legislature may choose not to act on it. You can go to the governor, or you can go to the executive heads of the administrative branch of government, and they may or may not decide to promulgate a regulation on something. But if you go to court, the court has to decide something. And this combination of people being put into court sometimes and usually not by their own choice, and the court having the necessity to act, underscores the need for courts to be impartial. We cannot have involuntary, agenda-driven processes in government and still hope people will maintain their confidence in them.
So that brings me to the question, distinguish between independence and impartiality.
It's a very good question. I think the word independence, in just my own opinion, has been overused. It sounds to some people as though judges put on a black robe and confuse themselves with a deity and they can do whatever they want to do. But that is not the case, and both of us have worn black robes.
Justice will agree with that.
Yeah.
Absolutely.
What we really mean by judicial independence is the right to follow the law and to render justice, and this is language out of the Code of Judicial Conduct, without fear or favor. That's what we should mean by judicial independence. It's another way of saying the courts have to have the power and the independence to be impartial. Only when the courts are impartial do they have a legitimate claim to independence.
Turn around.
This is such a confusing process because I think I watch the political process when we have elections, and you see candidate A and you see candidate B in I'm talking about non-judicial races, and their everything is built around their opinion on an issue. And then you throw into the same mix these judicial races where I'm guessing that the expectation is that your judges should not really have opinions at all in terms of these issues, but it's all done in the political process. So I think from the public's perception, it's very confusing. So anyway, what I wanted to ask both of you is to reiterate again for our viewers and for us what the role of the judge is, because it's not about opinion, and you guys spoke to that this morning very, very well. I just want to ask you to say that again. What is the role of the judge in the courtroom and through that process? Dean Burnett.
Well, I'll begin. Justice Trout's very eloquent on this. But the role of the judge is to be reflective and to bring an open mind. Even if there's a past history of how cases have been decided, the judge should be open to persuasion. The judge should look at each set of facts fresh. The judge should seriously and genuinely consider arguments about the law that are presented by counsel. The judge should not have pre-committed herself or himself to a particular outcome before a case is even brought to the court. If we do expect politicians in the other branches of government, I don't use the term politician derogatorily at all, but people in public life who are seeking elective office in other branches get where they are going by, in essence, making an agreement with the voters. If you elect me, I will accomplish these things that are on your objective, and the voters can decide. But that is not what judging is about.
Justice Trout.
Well, and I would add to that, judges are there to interpret the law. They're not there to make the law. That's not their role. And even though we hear that, I think nationally, in the selection process, I want somebody who will just interpret the law. That's very true. That's exactly what the judge is there to do. They're to take either the Constitution or the provisions of a statute adopted by the legislature and to look at that and say, I think this is what the drafters intended. Whether or not I personally think it's wise or a good decision is really irrelevant. I'm just simply there to say, I think that's what this means.
Much media coverage goes to sort of constitutional law cases, and the courts are required to interpret what the Constitution means and then set it side by side with a statute or regulation to see whether it is constitutional or not. And I think sometimes when people read news stories or they hear broadcast stories about the outcome, they only are told about the result, and then there's controversy about the reaction to it by various constituencies, and there is not, I would respectfully say, enough coverage of the underlying rule of law that was embodied in the decision. It is the duty of the courts, and Hamilton and Madison said so in the Federalist Papers, to say if a law is unconstitutional, and then John Marshall later said so in the U.S. Supreme Court in Marbury versus Madison and other cases. But if there is no conflict between the Constitution and a statute, it is the duty of the judge, as Justice Trout was pointing out, to follow the statute, even if the judge sitting in the legislature might not have voted for it.
On that note, we have to bring the program to conclusion. On behalf of our panel, I want to thank Justice Linda Koppel-Trout and Dean Don Burnett. What a wonderful program. And the good news is, ladies and gentlemen, that our guests will be back next week on this same program to continue our discussion of shadow of the Constitution, the attack on judicial impartiality. Particularly, we on that program will be addressing some other questions about state Supreme Courts and elections around the country in the last 6 or 8 years and what that has done possibly to this whole system. And I hope you will join us again next week for this continued enlightened discussion. Until then, please have a good week. I am Tony Stewart.
Recorded on the campus of North Idaho College, Public Forum is the longest-running in-house college production on PBS. Each episode is pre-recorded live and is an educational outreach from North Idaho College. Please join us at this same time next week for another edition of Public Forum on this public television station. Welcome to Public Forum, a community outreach program produced at North Idaho College on the shores of Lake Coeur d'Alene. Featuring guests from around the globe addressing a wide variety of subjects, Public Forum serves to educate and enlighten. Please join host and moderator, political scientist Tony Stewart, in welcoming today's guests.
I welcome you back to part 2 of a 2-week series titled Shadow over the Constitution, the Attack on Judicial Impartiality. Such an important topic and one you don't hear too much about, but that does not take away from its importance. We have our 2 guests back from last week, very distinguished guests, and we had a great program. I welcome first of all to the program Dean Don Burnett. He is the Dean of the University of Idaho College of Law, but he has a very impressive background. He was born in Idaho, and he received his BA, magna cum laude in economics from Harvard. He also has a JD, or Doctor of Jurisprudence, from the University of Chicago, and an LL.M. degree from the University of Virginia. He has a very distinguished career in Idaho. He was a clerk to the Chief Justice of the Idaho Supreme Court. He was an Assistant Attorney General for the state of Idaho, and then he entered private practice in Pocatello and became President of the Idaho State Bar. And he also served as the judge of the Shoshone-Bannock Tribal Court, and he was appointed to the Idaho Court of Appeals and later was re-elected to that position. And as I indicate, he's now Dean of the College of Law at Idaho. But prior to doing that, he also in 1990 became the Dean of the University of Louisville, Louis D. Brandeis School of Law, and returned to Idaho in 2002 to become our Dean. Welcome back. It was great having you last week.
Thank you. Glad to be with you again.
And I'm so equally pleased to have with us on the program again this week Justice Linda Koppel-Trout. She grew up in Idaho, also in Boise. She holds a BA and also a Doctor of Jurisprudence from the University of Idaho. She served as the magistrate judge in our state and as acting trial court administrator for the 2nd Judicial District. And she was elected to a position of a district court judge, serving Nez Perce and Clearwater counties. In 1992, she was appointed by then-Governor Cecil Andrus to be the first woman to ever serve on the Idaho Supreme Court. We've gone over 100 years without a woman on the court, and she has certainly served there with great distinction. She was elected twice by her colleagues on the court to serve 4-year terms as Chief Justice of the court. Welcome again. We're so pleased to have you here.
Thank you, Tony. It's great to be back.
And as always, I'm pleased to have our 2 regular panelists, Janelle Burke, who's an attorney in the state of Idaho, and next to her is Erna Reinhardt, who is Director of Public Relations at North Idaho College, and Attorney Janelle Burke will start the questioning.
Welcome again to our very distinguished guests. It's a pleasure to have you here and an honor to have you with us. My first question will be for Justice Trout. There are judicial canons. Judges aren't free to just do whatever they like. There is a judicial code of ethics, if you will. Can you tell us what you consider to be
some of the important canons as far as our discussion here is concerned, with impartiality and with selection?
Well, there are a number of them that govern the judge's conduct, not only as a candidate or campaigning, but also if they are successful in being elected or appointed to a position. Things that govern even more broadly than I think people would expect. For example, family and social obligations, or political connections, or the things that they may say, or conduct that they may do outside of the courthouse. There are canons that limit the judge's activities with the intent that the judge remain fair and impartial and avoid even the appearance that the judge is not fair and impartial. In addition to that, there are canons that govern the judge while campaigning, things that limit their ability to fundraise and solicit campaign contributions, that limit their ability to speak out on issues or express personal opinions on issues that may come before them as a judge. So that there are a number of limitations on what the judge can say and do, so that the public hopefully retains its level of confidence in the judge's impartiality.
Dean Burnett, how does money affect the ability up to these obligations under the judicial canons?
Well, that's the 21st century question that is facing the judiciary, and unfortunately it is one of the problems that's casting a shadow on the promise of neutrality embodied in our Constitution. In states where elections are held, judges, in order to either be elected in the first instance or re-elected if they were originally appointed, need to get a message out. And unfortunately, civics education in this country being what it is, voters respond to issues. They're not very well acquainted with the individuals. They don't look at the same things, say, a judicial council or a nominating commission would look at, which would be the intelligence of the individual and the legal ability, the integrity of the individual, and the capacity to be impartial. Instead, it's folks tend to look at judicial candidates the way they look at all candidates. And they say, what is that person saying that is going to be advantageous to me? Why should I align myself with this person and cast a vote for this individual? And regrettably, that's not what the judiciary should be about. The judiciary should not be in the business of trying to raise money based upon preferred positions, and should not be taking positions that later would cause a lack of impartiality if the judge sits on the court. In fact, to build on Justice Trout's answer, a judge has a duty to recuse under the canons embodied in our Code of Judicial Conduct whenever the judge's impartiality might reasonably be questioned. That's the language, when it might reasonably be questioned. And judges are precluded from making pledges and promises as to outcomes of issues that may come before them later. But that doesn't sound like campaigns, and that's the basic dichotomy. The judiciary has a role in society which does not lend itself to partisanship or taking positions in advance on issues. Very hard for folks to separate the judicial election from other kinds of elections, and money just exacerbates the problem.
Erna Reinhardt.
We've touched on some issues in last week's program and already in this week's program. I'd like to give you both an opportunity to suggest some solutions and improvements to the system that we may want to look at or try to implement. So Justice Trout, share some of those ideas with us.
Well, I think both of us mentioned last week that in Idaho we have two different systems. The magistrate judges in Idaho are on what's commonly called the Missouri Plan, or a retention election system, where they are appointed through a merit selection process, and then they sit for election in Idaho every 4 years on a yes-no ballot. And unless they receive a majority, 51% no votes, they're retained in office. So it takes out much of the fundraising, it takes out much of the face-to-face combat, and a lot of the challenges based upon issues, things that really are not appropriate in my view for judicial elections. Yet it retains accountability. It still gives the voters an opportunity to go in, and if they think a judge really truly is not carrying out their responsibilities, it gives the voters a way to remove the judge from office. But as a part of that, I think, and we don't have this yet in Idaho, I think an important component of that is some type of judicial performance evaluation. Utah, for example, along with other states, does that, so that the judges are routinely evaluated, and then a part of that evaluation is made available to the voters. And so hopefully when the voters go in to cast their ballot, they have some measuring stick, some way to know whether or not this candidate is worthy to be retained in office or really truly should not continue to be there. So I would advocate that kind of system for all levels of the judiciary in Idaho.
Excellent.
I think it's important, implicit in what Justice Trout said, that this performance evaluation does not have a philosophical litmus test in it. It's whether the judge has exhibited legal ability and intelligence in understanding and addressing issues, good communication skills, both orally and in writing, a high degree of personal integrity and honesty, and the capacity demonstrated to be impartial and not to show favoritism. One of the key phrases out of the Code of Judicial Conduct is the judge should render justice without fear or favor. That's the kind of evaluation that can be done in the system that Justice Trout is mentioning. Now, it's certainly true in retention elections that an interest group could campaign for someone not to be retained in office, and that is a risk. But the risk is minimized, as I think Justice Trout is suggesting, if a blue ribbon group, an independent group, has already evaluated the judge's performance and makes a recommendation as to whether the judge should be retained. It's important that both of us are talking about some kind of election. Sometimes folks think, well, this appointment system or merit selection system just sounds too elitist. You're kind of cutting the people out of it. That is not true at all. What we do suggest, though, is that the election should be crafted to minimize the downside of money coming into these elections and judges campaigning to take positions on issues upon which they are later expected to be impartial.
Do you feel that there is a movement within Idaho to make those ideas a reality?
I think there have been discussions in the past. I know, as a matter of fact, that the legislature created a committee shortly after my election to study judicial campaign fundraising. Do we want to do public fundraising in Idaho or public funding of judicial elections? But over the passage of time, I think interest wanes, and frankly, I don't see at this point in time any groundswell of support to change the system.
I think it will take the action of the concerned citizen groups, people who will stand up for impartiality. It's hard to do that because it's not a very motivational topic. Being partial is what's motivational. That gets the partisan juices flowing. But programs like this, civic-minded organizations can say, even though politics is fun, it belongs somewhere else in government. And we need to stand up for an impartial judiciary. And I do think that the bench and the bar, that is the judiciary and the legal profession, and citizen leadership will be very important. This is not just an intramural issue for lawyers and judges, but citizen leadership could produce some very important results. The question about money may be the catalyst because the amount of money that's coming into judicial campaigns is rising. Justice Trout earlier mentioned, and also last week, that in the 1990s the trend was upward. 2000 was a threshold year for a new level of expenditure on state judicial campaigns. It went higher in 2002. It went higher in 2004. It went higher in 2006. Among state Supreme Court justices who ran for election and who raised any money, the median amount raised by those candidates was nearly $250,000. Now, where is that money coming from, and what are the expectations of people who make those contributions? It's not the judge's fault. They have to operate within the system. We as citizens have created, or we are acquiescing in this system, and that's not even the whole of it. Then you have third-party advocacy money coming in. In recent elections in Washington, it was nationally reported that about $4.5 million was spent in appellate level judicial campaigns in Washington, and about 60% of that money came from advocacy groups. Now, what did they expect to get from this? Are they just interested in good government, or is there some other explanation?
My question is for Justice Trout, and it goes back to the time when you were on the court. I was an expert witness in the reapportionment case of the 80s, and drew the plan that was adopted for 8 years, and I was speaking with an editorial board, and they said, how on earth do you get the attention of voters on reapportionment? You know, it's not about, reporters say it's not about ice cream, it's not about sex, so how do we deal with it? And he fell upon a plan, and his plan was that let's talk about a football game. And so that brings me to the question that you used earlier today, Justice Page in Minnesota. I think sometimes through an analogy we can really get through to the citizenry. So why don't you share with us the football analogy of referees, and that will help people understand the importance of impartiality with judges also.
Well, as I mentioned earlier, Justice Page, it was particularly an interesting analogy because in his earlier life, before he came on the Minnesota Supreme Court, he was a very well-known and highly respected professional football player for the Minnesota Vikings. And his analogy was, no football fan in their right mind would think it was right for a football referee to have a particular alignment with one team or the other. They would be mortally offended at that. They absolutely want referees that are open-minded and will call the plays as they ought to be called. And when he used that analogy, and he said, why in the world would people think differently of the judiciary, which is called upon to make some pretty important life-changing decisions on occasion? Why wouldn't people expect the same kind of fairness from their judges, and why would they tolerate a judge that was indicating a bias or a favor for one side or the other of an issue?
I think it's a wonderful analogy. People really understand that. Dean Burnett, I want to ask a question about, again, a case